It's really pretty straightforward if you follow the instructions, but there's a lot of issues with the map, with the legal description, and I always joke that you can tell when you have a real grower, because a real grower will drive around a center pivot and shoot his coordinates and not actually have his coordinates inside the registered land area, which, we can't work with that. And then people that still own their old maps that they probably bought 10 years ago, and they have to unfold them and prove to themselves that they can still get the legal description off of some map that's probably been in their glove box for 10 years, But the best thing to do is follow the instructions, use the tools, which are, EarthPoint works great for legal descriptions in Colorado, and the Google Earth Pro works great for actually making a map that can be verified. The problem, we run into a lot of problems with those issues right there. So,
I'll add a couple of other issues. Is really when people fill out these applications, they need to sit down. Until they formally do that, we're just going to go ahead and provide, anybody who's been listed as a contact the information, and we do have a form on our website if you want to have a change in contact. So you really need to be thinking about that. Landowners really need to be thinking about if they're leasing their land to a grower, making sure that they have they've discussed this, because I can't tell you the number of landowners that have called us and they weren't on the application, they're not a contact. And we try to take that very seriously. I mean, before we talk to somebody, I will sit there and say, who are you? And if they're not listed as a contact, I'll tell them I'm not authorized to speak to you, because who wants their information to be shared with people that aren't authorized to receive it? So we try really hard to take that seriously. We do take it seriously, and we do try to check that out all the time. And so those are the kinds of things people really need to think about. They really need to think about their corporations. Again, sometimes there's a breakdown, and now all of a sudden, well, we've decided that we're going to just, this isn't working out, we want to switch this to another sort of corporate entity. You can't do that. Once it's registered under a specific corporate entity, it has to stay that way. And the only solution is to, close that registration and open a new one. So there's those kinds of things besides just the registered land area and the maps and the GPS and all those kinds of things. It's relationship. It's and really thinking that through so that landowners aren't frustrated, people who are leasing property aren't frustrated, and and just trying to make sure that this is successful.
I just want to add that there is a technology issue as well, because if some people don't have computers, some people don't have computers that can handle the programs that you need, or you live in a rural area where you don't have high-speed internet. So the things that we kind of take for granted on the Front Range don't really pertain to the rest of the state as far as those requirements go.
That's really good insight right there. So then, presuming now that someone successfully registers, they give you 30 days, their registration's processed, and now they're good to go. Let's talk a little bit about the, planting reports. There's both a function, within the application itself, but also, potentially post-application process. Can you talk about a little about the interplay between those two? Sure.
Well, one of the things that we're trying to really communicate to people is to learn about what you're signing up for. We try to provide you with all this information at the onset. If you look at the application, we send you a lot of information. I know it's on one page, but really try to understand after you are registered, you're no longer an applicant, now you're an applicant, what it is that you've committed to. What have you agreed to do to stay in compliance? That should be an afterthought. And so, that's the time to be thinking about, what is it that I'm supposed to be doing? What reports am I supposed to be submitting? When am I supposed to be submitting those reports? Because if you don't really understand this from the onset and you're trying to just sort of, backpedal or trying to get this done, it sort of creates chaos for everybody. And I think it's really, it's more than, we have to take all kinds of things when we get a license, a driver's license, whatever it may be. I mean, there's rights that come with it, but there's also responsibility. And so I think that's the most important message is really think about this and read about this on the front end. And then in terms of once you are, in the program, again, we have pre-planting reports, and we need those, not so much because of what necessarily the content of what you plan to plant, but more to know that you intend to grow industrial hemp. That's essentially what it is that's what you're signing up for, is to grow industrial hemp. And quite frankly, not marijuana, because this is an industrial hemp program. And then for planting reports, again, the idea is reports are a communication tool. It's a way of saying, okay, I've registered to grow industrial hemp. This is where I've planted it. It's on this part of my registered land area, because a lot of people will register a land area that's far larger than where they're actually going to grow. So the planting report sort of hones that down and tells us, okay, and of course everybody wants those figures. They want to know, plus it's data. I mean, they don't want to just know how many acres have we registered. We want to know how many acres have been planted, how many have been harvested. Well, that's where we derive that information. So that's sort of the purpose of the planting report, is it's to communicate with the CDA and let us know kind of what you're doing in terms of your grow. And then we also, we ask for varieties and different kinds of information that, we're trying to capture that so that those are things that we can, hopefully, start to see big pictures on as the years go by, and now. And then finally, with regard to the harvest report, so it sort of follows, okay, I've registered this land area, I've planted, now this is what I'm harvesting, because there can be a discrepancy between what you've planted and what you've harvested for a variety of reasons, including, like I referred to earlier, plants have died, they've been eaten by bugs, whatever the case may be. So again, it's our way of sort of tracking all that. And it's a compliance measure, because quite frankly, if we get a call from law enforcement, and we do get calls from law enforcement, it's really great when we can look at your file while we're on the phone and say, you know what we can tell you is they're in compliance. They've filled out their reports. We don't give them any specific information about what's in those reports, but just to be able to say they're complying with the program. That really, really does help protect you.
Great. And Terry, did you have a follow-up comment?
No, I don't.
Okay. And then to follow up to that, for hypothetical purposes, what if someone submits with their initial application, a particular planting report that they're going to grow 2 strains, but then after the fact they decide they want to actually grow 3 or 4? Mm-hmm. What does that look like? What does that look like from your perspective in terms of amending that?
So, typically, it doesn't come up too often, because the planting report is supposed to be what was actually planted. Sure.
I should say the pre-planting report.
The pre-planting. Honestly, we don't care. That's your discretion to be able to decide, what you're going to plant, what variety. So the pre-planting report is, it's a necessary tool, but it's not anything that you're bound to. And I do get a lot of people asking about that, so I'm glad you're bringing it up. It's a great point to clarify, but we understand that's why it's called a pre-planting report, because we understand that for whatever reason, and there can be a myriad of them, you may have decided now you're going to plant something else instead of what you intended to do, and that's fine. They don't have to mirror each other.
Thanks for clarifying that. So then, let's move into the sampling, testing, and harvest component of the CDA's program. Terry, maybe this is better for you. Can you talk about the testing protocols or the sampling protocols for CDA and what that looks like?
Sure. Overall, or just in specific terms?
Just in overall. Feel free to.
The overall sampling piece. If you're talking about what part of the plant is sampled, that kind of thing. Yeah.
Yes.
Basically, the plants, it's been the policy since the beginning, which was, predates us anyway. But, they decided that the best way to do this was to sample the top 2 inches of female flowers, and that's what the CDA does. So depending on the size of the location or what varieties are out there, how many samples they want to gather. You know, that usually the best thing for the department would be to take one composite sample of a whole farm or a whole grow site. And, you know, right now people can take, you know, individual varieties and take them separate, you know, to try to make sure that you're at 0.3. But, you know, in an ideal world, you'd run one sample per registered land area, and you would just have a composite sample of that. So what they do now is, I mean, if you want to pay the price, what we've done in the past, and, you know, that's probably going to change, just flowers from female plants or just top 2 inches of flower, can also be any part of the plant, in the upper part of the plant in full sunshine on a trim plant. So.
Can I expound upon that a little bit? Are you done, Terry?
If you're in a large field, you know, the samples could be as big as half a grocery bag, you know, so.
Okay. Well, I'll just expound upon that a little bit. Just in terms of, you know, taking one sample, and we talk about this, but as the person who has to call and tell people that their crop tested high, I would prefer not to have your whole field have to be destroyed or utilized in a manner. So, you know, I certainly can see where having a variety tested, and then of course that you know, you don't have the risk of losing your whole field. So, you know, I'm very cognizant of that, and that's important. That said, we're just not a testing facility, and we're not in a position where we can just take multiple samples and do multiple testing. We just, you know, we really don't have those kinds of resources, and that's something that we're keeping a close eye on and trying to make sure that we're just not going out there and just testing a large number of varieties, because we just don't have the resources to do that. In terms of the notification, I just want to speak to that a little bit. There's two different kinds of inspections. We have our routine mandatory inspections, and those are inspections that are announced. Registrants, and some of them have received them in the last day or so, received notification that they've been chosen for inspection. The commissioner, the CDA, has the authority to inspect 100%, but we don't do that simply because, you know, largely because, I should say, because of, you know, resources. But if you're chosen, that's part of what you sign up for. That goes along with understanding what you signed up for and understanding the program. You've agreed when you became a registrant that that you have authority to do unannounced inspections. And there's a couple of elements that we need to meet if we think that there's a possibility. Essentially, if we feel that there may be a violation of some sort going on, or if the registrant's not complying with reporting requirements. And so we do some unannounced inspections. I mean, we take those seriously, try to really make sure that we really feel that it's warranted, but we do some of those as well.
And so there's several points of follow-up, so we're going to be on this topic for a little bit here. Terry or Maureen, can you clarify, you know, we a lot in the industry, a lot in the room, you know, would recognize the term hot hemp. What does that mean to the CDA in terms of hot hemp, and at what point does it become hot?
Well, I mean, strictly speaking, hot hemp means hemp that exceeds 0.3% THC concentrate on a dry weight basis, and so that's not something. I mean, that constitutionally, it defines industrial hemp, and that's been what the limit has been set for what defines industrial hemp, and then as it moves into marijuana. So anything that exceeds that percentage would be regarded as hot.
And at that point, as you referenced the Constitution, does that then, render that material effectively marijuana under Colorado law?
Well, we don't necessarily, and I'm not trying to, it's just that I would look at it as it's not hemp.
Sure. And
it's not my jurisdiction or that's not my expertise beyond that. So, sure. But it's not, it's a definitive number. It's there. It's objective.